So thank you everyone for joining us today to join this webinar. For those of you that don't know me, my name's Andy Whitaker. I'm a partner at the employment team at Boyce Turner, and I've been asked today to hold this run this BCL webinar to look at an update on the Employment Rights Bill. We've got about 45 minutes or so today scheduled. What I'm going to do is talk and see how we go on. There is a chat function available, so if you have any questions, you can enter those into the box. Depending on how we're doing it for timing at the end, I will see if there's some that I can pick up when we conclude the webinar. If we don't have time, or if I'm feeling far too tired, then we will make sure that we do respond to every question that we receive in writing after the event. So don't worry, if you do have any queries or questions, do let me know and we'll make sure we get a response to you. So what are we doing today is the question. Well, we're looking at the Employment Rights Bill, and many of you, I'm sure, will have been to similar webinars or attended sessions or done your own reading or research into this matter over the last couple of years, because the Employment Rights Bill is something that's been long trailed. It's been something that we have been expecting for an extended period of time, because of the Labour government was very clear prior to it coming into power that it had big plans to shake up the employment law rules in the UK. So we had white papers, green papers, announcements, and then King's Speech, and then finally we had the Employment Rights Bill that was published last October. So there's been a lot of chat about this over the last couple of years, and it is wide-ranging. There is a lot that is included in it, and what I'm proposing to do today is to not go through it line by line. I'm sure you'll be very pleased to hear. You'll see that there is quite a few bullet points on the agenda there. I'm not proposing to go into detail on every specific principle, for example, in respect of unfair dismissal rights, because I suspect many of you will know about the broad details of it. I'm going to do a high-level coverage of what the changes are, but I'm going to pick out specifically amendments that have arisen during the course of the bill's progress through Parliament. There were some specific amendments that were announced back in March of this year, and also the employment law gods have been smiling upon me because there has been some new changes or some announcements in the last week or so that are relevant to the Employment Rights Bill, and we'll touch on those as we go through. I'm also going to talk, because I'm mindful of the people that I'm speaking to this morning, I'm going to talk as well a little bit about what you should be doing and to prepare your businesses and to engage with the key stakeholders within the business to get yourself ready for the introduction of these new rights as and when they come into force. So, as I've said, the Employment Rights Bill has been a long time in the making. We had the announcement back in October of last year of the plan to make work pay. And you'll see here that the bill will support employers, workers, unions to get Britain moving forward and fulfilling a commitment to introduce legislation within 100 days. It will also update and modernise the legislative framework in relation to employment rights. So that's the big intention of the bill. We had to wait 3 months to get that outline, and still after that publication there's a lot of information still that we don't know about. And indeed, although there is a draft bill, a lot will depend on subsequent secondary legislation over the next couple of years to actually put the meat on the bones of the various pieces of the provisions that have been introduced. It is, however, a very comprehensive package of changes. I recently celebrated my 17th anniversary of, well, the 17-year anniversary working at Boyce Turner. And it made me think that 17 years ago, the employment law landscape probably wasn't all that different. Yes, we've seen some enhanced rights, some enhanced protections around different protected characteristics. We've also seen things like gender pay gap reporting introduced, and rules around modern slavery. But fundamentally, most of the rules have stayed broadly unchanged from 17 years ago. But you go back 17 years from then, and all of a sudden you're entering the late 80s, early 90s, and that's before the Employment Rights Act and the updated rules around unfair dismissal. It's before the Disability Discrimination Act as well, so protection for those individuals who are disabled, before the Trade Union Labour Relations Act as well, so all the updated rules on labour relations and interactions with trade unions. So actually, we have had a period of quite a lot of calm and tranquility as far as employment law is concerned over the last 20 years or so. And this is quite a substantial change. There are quite a few areas that are going to be markedly different to where they were before. As I mentioned earlier, we saw some amendments made to the draft bill in March. And as I've also mentioned, we're going to be waiting for some secondary legislation to put some more meat on the bone in due course. I wanted to put a little bit of context to this as well, because another thing that was published last month, so back in June, was the most recent quarterly update about the employment tribunals in the UK, and it does make for some rather sobering reading. So as you see, I picked out some key stats from this update from last month. And as you'll see, the open individual cases recorded, so that's the number of cases where you have an individual claimant and individual respondents, have risen from around 33,000 a year or so ago up to 45,000. So that's a substantial increase in the number of claims being pursued at this time. And with the current funding model that's available to the employment tribunals, over the last couple of years, they've managed to handle about 32,000 cases a year. So as you can see, there is an inability to deal with the current caseloads before the tribunal. And many of you will have felt that anecdotally, or indeed in practice. If you've been engaged in litigation within your businesses, you will have seen things take a very long time. Administration at the tribunal will take quite some time to get documents to you, or to get decisions or judgments, or even ET1s if they've been submitted. It's not unusual to wait for several months before you receive an ET1, before you even know a claim's been issued. So we know that the tribunals are creaking at the seams. I put some stats up there. Now, it's important to make the point that actually the waiting times, etc., do vary from region to region, but London South is a particularly bad one at the moment. The whole of the South East is quite gummed up. But as you'll see from the slide there, London South, if you're looking to get a 10-day listing, a case listed, then we're looking potentially at 2027, 2028 potentially, so a long way for that. Even for relatively simple unfair dismissal cases that may only be 2 days, 3 to 5 days, we're not going to see those listed until the autumn of next year. So this is a problem, because it's a problem for claimants, because they have rights that they wish to enforce against their employers or former employers, and they have to wait a very long time to do that. But it's also a problem for businesses as well, because you're then waiting for an extended period of time with considerable uncertainty about the outcome of particular cases. And also, employees move on, you lose your witnesses, there's issues with memory. Can you recall everything that happened with clarity a couple of years back? So the delay in actually matters being dealt with at the tribunal is of assistance to no one, frankly. It's a real problem. And the Employment Rights Bill is intended to enhance or enshrine new rights in the employment law field. And there's insufficient funding to deal with the claims as they currently are. 22% of the claims before the tribunal at the moment are unfair dismissal claims. And as most of you will know, currently to bring an ordinary unfair dismissal claim, you need to have 2 years qualifying service. Hold that thought as we go through the discussion this morning, and about how some of these changes might impact upon the pressure that's currently on the tribunals. So moving on then, where are we as far as the bill is concerned? Well, it has completed the first stage in the House of Lords. Committee stage ended back in June of this year, so last month. There are still some additional stages that it needs to go through in the Lords as a report stage. 14th of July, a second reading, there will then be a third and final reading. Now, the government intended to try and get this bill passed before the summer recess, so that's towards the end of July. I do not think that is going to happen. There's going to be a bit of backwards and forwards, as there always is. There's been quite a few technical amendments proposed by the Lords, which will be pushed back on, one would imagine. But the likelihood of all of this getting done in the next 3 weeks or so I think is unlikely. So instead, we're probably looking at the bill coming into, or being passed, I should say, probably after the summer recess, so sometime maybe in September. But what does that actually mean in practical terms for businesses? How can they plan for this? Well, as I said, the employment law gods were smiling on me earlier this week, and the government published on Tuesday an implementation roadmap setting out both in terms of consultation processes they're going to run, when they are going to commence on the various pieces of either secondary legislation or just principles in general as to what they might want to include in some of the new regulations, or indeed the implementation of specific rights and what the timeline looks for that. So that's really quite helpful. And as we go through the slides this morning, you'll see I've highlighted, as we go through the various rights, when the implementation roadmap anticipates those new rights and regulations are going to come into force. So let's start off with the big one, as far as most people are concerned, and that's around unfair dismissal. As most of you will know, the rule as it currently stands is to be able to bring a straightforward unfair dismissal claim, you need to have 2 years qualifying service. Now, it is the case that that period of qualifying service has changed over the years. It's normally changed dependent upon the government that's in power. When we have a Labour government, it tends to mean that the qualifying service period is reduced. And when a Conservative government comes into force, the qualifying service period then goes back up again. So it's not unusual for that to flex. What is unusual is the government's intention to introduce protection from unfair dismissal from day one. Now, what does that actually mean in practice? We know that previously there has been protection in the event of dismissals for particular protected reasons, so trade union activities or pregnancy. But to be able to bring a claim right from the outset of your employment, how's that actually going to work in practice? Well, the government has suggested that the way this is going to work is that there's going to be an initial period of employment. And during that initial period of employment, that you will have protection from dismissal in that an employer will be obligated to go through a light touch process with you prior to the termination of your employment. Now, specifically what that light touch is going to look like, again, is something that we're going to need to wait for specific regulations to outline for us in due course. But it's anticipated that that light touch process will be applicable in specific areas. So I've got them on the slide there. So it's in respect of conduct, capability, illegality, or some other substantial reason. Now, those will be familiar to most of you. If you practice in employment law at all, you'll recognize those as being the potentially fair reasons to dismiss. The potentially fair reasons, I should say, to dismiss. One that's missing there, of course, is redundancy. So at the moment, if someone has a qualifying period of 2 years, then if you propose to dismiss them on the grounds of redundancy, that is a potentially fair reason, and you can justify it by going through a fair redundancy process. During the initial period of employment, redundancy dismissals are explicitly excluded from that. So what that's going to mean in practice is that if you do have an individual with a limited period of service, and there is a need to make redundancies, they will need to be treated in the same way as anyone else with relevant qualifying service or who is outside the initial period of employment, which we anticipate being as about 9 months. So once someone's been with you for more than 9 months, then the initial period of employment rules won't apply. The full protections from unfair dismissal will apply. But if you've got someone who's been with you just for 6 months and there's a necessity to run a redundancy process that they're affected by, then you would have to treat them in the same way that you would treat anyone else with the relevant qualifying service. You cannot apply these initial period of employment rules, the light touch process for them. But even in respect of the light touch process, there's some uncertainty about what that actually means. So for example, there is an expectation that there will be a meeting of some sort. Now, I suppose in terms of general fairness, that sort of makes sense, doesn't it? But it is potentially an issue for employers. I have been advising employers for many years, and it is not uncommon for an employer to ring me and say, well, we've got this issue with this particular individual. It's really not working out. We're thinking of potentially inviting them to a meeting to discuss this. we're going to send them an invite. We're going to set out to them what we're going to talk to them about. They've only been with us a few months, but we want to talk to them about this, and we think we're probably going to terminate their employment. And my advice in those circumstances will often be, don't do that. Just call them into a meeting room and just tell them that you're terminating their employment, and don't give them any advance warning of that. If you think there is a possibility that you might not wish to terminate their employment and you might wish to go through some sort of performance process with them or give them an opportunity to improve, then by all means put in place some sort of formal process. But if you've already made up your mind that you're just going to part company, then as soon as you invite someone to a meeting, and especially if you give them advance warning of what that's going to be, there's every prospect that that individual may then not turn up. They could get signed off sick, they could raise a grievance, there could be a whole host of things that could happen which could delay or stymie the process. So it's often good practice, even if it feels slightly unfair, if you use a sort of layman's terms about it, to just carry out a meeting without any prior knowledge. It's anticipated that the introduction of this initial period of employment and these light touch rules will mean that that will no longer be possible, and there will be an obligation for you to carry out a meeting with those individuals. There's also some uncertainty before you make a decision to dismiss. There's also some uncertainty about how do you justify those reasons and what you need to prove in order to rely upon a dismissal under any of those particular heads. It is noted that following the consultation, one of the amendments that was announced back in March is that there will be a different compensation regime for individuals who are dismissed during the initial period of employment following the light touch process. If a tribunal concludes that there has been unfair or the process has not been properly followed, compensation will be available to individuals, but it will not be the same as what might be recoverable if someone has the full protection and they're dismissed after that initial period of employment. Again, we are waiting for further regulations to understand exactly what that might look like and how that compensation might be calculated. But you can see that this is quite a fundamental shake-up in the unfair dismissal rules. And I told you to hold that thought about the number of claims before the tribunal at the moment. Bearing in mind, we have that number of claims at the moment, 22% of which are unfair dismissal claims. And that's where individuals need more than 2 years service. If now anyone from the commencement of their employment has a right to bring a claim about the termination of their employment, even if it's under these light touch principles, then we can see that there's a substantially greater scope for claims to be made, and that potentially can place a significant amount of additional strain and stress upon the already creaking employment tribunal service. It's all very well providing these rights, and this is certainly not intended to be a political webinar in any way, shape, or form, but it's one thing to provide those rights, but it's another thing to actually enable people to enforce them, and we'll see how possible that proves to be once these rules are introduced. So as far as what we need to do, well, we need to be thinking about our recruitment processes and also our induction processes, because it's going to put more pressure on us to try and make sure that we're making good recruitment decisions, but it's also going to put pressure on us to actually conduct induction processes well. Many recruitment processes fail because it's the wrong person for the wrong job, but they can also fail as well because management fails to properly engage with the individual from the commencement of their employment, fails to provide them an adequate training or guidance as to what they need. If we are then going to have these additional protections, it's going to be much harder to make decisions to let people go if we believe that the recruitment has failed, and therefore there's going to be much more focus and onus on managers to make sure that they are properly engaged in both recruitment but also in induction. So we need to think about how we're going to train our managers in that. We need to think, do we have sufficient HR systems to be able to track the relevant dates as well, so we understand what processes we're on. Might be useful as well to have a look at our exit interviews as well over the next year or so to understand why people are leaving, especially those people that are leaving at early stages. Is there a particular issue there with our induction exercises or indeed with recruitment that we need to address and try to get right before the laws are introduced? And the good news, I said I'd highlighted for you some of the timelines here. You'll see that the consultation on exactly how these light touch rules are going to work is going to commence later on this summer, but it's not anticipated that these day one rights will be introduced until 2027. So we do have quite some time to prepare for this, which is good news. Potentially it gives the tribunal service an opportunity to clear some of its backlog before these rights are introduced, but I'm not holding my breath on that one. But in any event, I think it is worthwhile at least having this an understanding that this is on its way. And in any event, if we can do things that enable us to improve our retention and get our recruitment better, then that's got to be a good thing, regardless of protecting ourselves in respect of unfair dismissal claims in due course. So next up, fire and rehire. So we know that when the bill was published, we were advised that there was going to be a much reduced scope for businesses to potentially use the fire and rehire mechanism to bring about changes to contracts of employment. Many of you may be aware of this, but if you're unable to negotiate a change to terms and conditions with a cohort of individuals, or indeed an individual, then you can potentially take a rather nuclear option of giving them notice to terminate their employment and then offer them new terms of employment to commence the day after their notice expires. That still represents a dismissal, and it still therefore gives the individual the right to pursue a claim for unfair dismissal. But depending upon the changes that you're looking to introduce, and depending upon the nature of the consultation that you engage with the individual, it's possible to defend such a claim. The government perceives this as being a bad thing, generally speaking, and so the original version of the bill outlined that it would be automatically unfair dismissal to engage in a hire and refire exercise, or a fire and replace exercise, so where you dismiss someone and you hire a new bunch of individuals to work on the revised terms, unless there is substantial financial difficulties that will affect the businesses as a going concern. So not just, well, times are a bit tight and this is a bit tricky and we'd like to save some money here, but this does need to be sort of an existential crisis for the business if you want to try and use this process. And employees can claim a protective award in the event that they are dismissed in these circumstances. So what's happened here in terms of the amendment? Well, the amendment is that initially it was intended that employees will be able to seek interim relief in respect of a fire and rehire process. So essentially they could make an application to the courts to prevent their dismissal from taking effect. But the government has concluded after consultation that actually there's sufficient protection being afforded to the employees under the new bill, and that actually going and introducing interim relief as a method or a new tool for the employees would be taking a step too far. However, and we're going to talk about collective redundancy in a second as well, the protective award is intended to be doubled from 90 days to 180 days. So it's quite a sanction upon employers in the event that they do go down this route. This is in response, frankly, to a number of quite high-profile cases over the last few years where employers have followed this process of firing a cohort of individuals and offering terms. And even if they are mindful that they might get a sanction for it, have factored that into their decision making. So the higher the protective award, the greater the deterrent is on businesses looking to take this step. Again, you'll note consultation on how this is going to be implemented and the relevant regulations is due to commence this autumn, looking then to come into force in October of next year, so next autumn. So we've got a little bit of time on this one. Collective redundancy, this was another potentially big change that was introduced in the Employment Rights Bill. As it currently stands, if you are proposing to dismiss more than 20 people redundant, more than 20 people at a particular establishment in a 90-day period, there's an obligation to collectively consult. And also there is minimum consultation process as well, and an award that's payable to individuals where there's been a failure to consult in accordance with the regulations. But the original bill anticipated that it would remove the one establishment clause. And this caused a significant amount of consternation. For those of you with long enough memories, there was a case involving Woolworths in the fallout of the Woolworths closures many years ago, when the courts initially concluded that actually at one establishment should be read widely enough to include an entire business organisation, so not just at one particular site. Now, that was quickly overturned on appeal, and everyone took a very big sigh of relief. But changing and removing the at one establishment provision would mean that if you're a large organisation with many sites, there will be an obligation to keep track of all the redundancies that you're making across your entire business to understand whether you get over that 20 individuals within a 90-day period that may potentially be made redundant. So that puts quite an additional administrative burden on businesses, a bit of a headache as well as to how you might manage those redundancy consultation exercises as well. Now, the amendment that was announced back in March is that although they are looking to beef up the rules around collective consultation and vary the one establishment rule a bit, they weren't going to be quite as drastic as initially been announced. So we still have collective consultation being triggered if we have 20 or more redundancies at one particular establishment, or, this is the new part, if there are redundancies across the organisation at another number yet to be set. Okay, so again, we don't know exactly what that means. It might be, for example, that they'll look at it as a percentage of the total employee population. So if they're all more than 10% of the entire working population of a company, that might trigger the obligation to consult with everyone. Or it may be that it's a specific number, so more than 100 individuals, for example, that would trigger the consultation obligations. But even if those triggers are met, you will be able to treat the consultation process as separate in that you wouldn't necessarily need to consult with all of the individuals at a site in Aberdeen together with all of the individuals that are being potentially made redundant in Devon. So you could treat them all as a different process. But even if you had 50 people in Devon and only 5 people in Aberdeen, if you're over that, let's say it's the 10% of the employee population threshold, then as the rules currently stand, you could ignore the Aberdeen employees for that purpose. You wouldn't have to involve them in a collective consultation process. But under these new rules, if that percentage or total number of redundancies trigger is hit, then even if you've got small locations with just a small number of individuals who are being made redundant, then the collective rules would apply to them. Again, I've already mentioned the interim relief provisions have been dropped, so that's gone. But we have seen the protective award increase from 90 up to 180 days. So again, that's quite a substantial financial sanction in the event that an employer fails to collectively consult with their employees where these obligations are triggered. So again, when is all this coming into force? Well, actually, the protective award increase is quite soon. So where there is a failure to comply with their obligations as far as collective consultation is concerned, we are looking at April 2026, so only next spring that might be introduced. As far as the actual changes and trying to understand when these triggers might be hit and what that percentage number might be, for example, well, consultation is going to commence on that early next year, but we're not looking for that to be in force until 2027. So again, it's not a headache that's imminently incoming, but it is still something that is planned and it will potentially have quite an impact. So we need to think about well, again, do we have an HR system that enables us to track, and do we track the number of redundancies that are being made across the country within a particular employer? Because if we don't, that's something that we probably need to think about. And there's going to be increased risk and costs potentially associated with redundancies, especially if, and I've noted too, that if the consultation periods, the minimum consultation periods are increased, then that's another potential implication for businesses and an additional cost that they may incur. So moving on to the next point, 0 hours workers. So again, this has been a substantial concern for businesses. The new rights being introduced for those engaged on 0 hours workers. You'll see on the left of the slide there, the original bill setting out what those rights would be. This obligation to provide guaranteed hours for those on 0 or low hours. Again, we're uncertain what low hours might be, and that's still uncertain, and that will be something that we dealt with in consultation at a later date. In addition, there's an obligation to provide notice when we're cancelling or curtailing or changing shifts to those on 0 hours workers, 0 hours contracts rather, and also an obligation to provide a compensation where we're providing that cancellation or curtailment at short notice. What have we got now following the amendments back in March? Well, we still have these rules as they were, but following some quite heavy lobbying by a number of business organisations, we have seen some changes. So, for example, we now know that it may be possible for particular employers to opt out of these obligations if they enter into a collective bargaining agreement in respect of how they're going to deal with 0 hours contracts. There also may be provisions that are introduced around genuinely temporary work as well. So if we're talking about seasonal individuals who are hired either over the Christmas season or over the summer season, whatever that might be, then that might be something that's available in particular sectors and in the particular circumstances. Again, exactly what that all means is going to be something that we're going to have to wait for further legislation to flesh out for us. But one substantial change that we have seen following the March amendments is around agency workers. So there was a suggestion or a thought that perhaps one way around these obligations, or an avoidance mechanism, I should say, would be to simply engage individuals through agencies. And the government has recognised that as a potential risk and a potential avoidance method. And so therefore, if we are looking to circumvent those rules by using agency workers on 0 hours basis, so simply engage these individuals through agencies, well, they will now also be covered by the 0 hours worker rules as well. There's some provisions about who takes up the responsibility and who's liable for ensuring that the guaranteed hours are offered, who's going to be responsible for paying any late curtailment charges as well. What I would say on this is that in terms of our preparation for the implementation of these changes, we want to be looking at our contracts with our agencies. If we are engaging agency staff on 0 hours contracts, then we need to be making sure that we understand what our obligations might be and who's picking up the various costs that are associated with those sort of late curtailments. So we need to be thinking about our workforce as well. Do we use 0 hours contractors? Do we use them appropriately as well? Are these individuals genuinely 0 hours contractors? Are they individuals who do variable amounts of work for us over a particular period of time? A couple of hours one week, 20 hours the next, then 5 the next, then 40 the next, and then none for a few weeks. Well, those seem to be individuals who might be appropriate to continue to retain on 0 hours contracts. But if we've got individuals who are engaged on 0 hours contracts, but the reality is that they've been doing the same number of hours for us for many months, if not years, it's probably worth thinking about whether there is a more appropriate way to engage with these individuals and do a bit of an audit of the contracts that we have in place. You'll see again my little orange highlights there. The consultation on how all this is going to work is going to commence in the autumn of next year, and it's looking only to be introduced in 2027. So there was some concern about how this would all impact upon businesses and how it would all impact them in the relatively short term. As you can see, this remains a medium to long-term challenge for us rather than something that's going to be implemented very soon. But nonetheless, I do think it is appropriate for businesses to be looking again at their 0 hours contractors, whether they're workers or employees, and understanding, are we using them in an appropriate way, or is there a better way that we can potentially be engaging with those individuals? There's some rule changes around trade unions as well. So there's going to be this specific right for trade unions to request and be given access, whether it be physical access or remote access, so electronic access, to workplaces in order to recruit members, to organise, or for collective bargaining purposes. There is also going to be an obligation upon employers to inform their employees of the rights to join unions, and also to regularly update staff about that ability. There's also some rules that are going to slim down and make slightly easier the process of engaging in industrial action. There's some rules around some heightened protection for trade union reps and members as well. Now, as far as what we're looking at here, as far as the rights of access is concerned, well, from royal assent, so whenever that is granted, we're looking at those a repeal of the minimum service levels that apply in some sectors. So specifically in sort of crucial sectors, there were some rules introduced by the previous government about minimum service levels having to be provided. The government is proposing to walk those back entirely. The simplification of industrial action process, again, that's something that's looking to be introduced very early on. And the enhanced protection from dismissal from industrial action, again, that's something that we're going to be dealing with once royal assent is granted. For the other changes to the rules around trade unions, we're looking for a consultation that's due to start this autumn, and then those rules potentially coming into force later on in 2026. Just around trade union recognition, I'll just sort of highlight this because it's quite an important point, I think, to notice. If you do have trade union activity within your workplaces, but you don't currently have a recognised union, the statutory recognition process is really pretty complicated. So a union can approach you and they can seek to negotiate with you recognition, but if you reject that or you're not interested in it, to actually go to the CAC and to actually get some sort of statutory recognition, that's quite a challenging process to go through. You need a 10% of the proposed bargaining unit must be union members, you know, majority likely to support the recognition, and then it's only then granted if you get 50% of the bargaining unit and then union members, or a ballot is held and you get a majority of votes cast are in favour, and at least 40% of all the people in that bargaining unit have voted as well. So there's some quite a lot of hurdles for a union to leap over in order to gain statutory recognition if you're unwilling to agree to it on a voluntary basis. The rules propose quite a simplification of this process. You'll see on the slide there, a reduction in union membership potentially down as far as 2%, remove the 40% turnout requirement in respect of any recognition ballot, also remove sort of service level restrictions too. One method that's been used in the past is where there's a potential recognition ballot that's coming in. An employer might recruit a whole bunch of new individuals and place them into a particular bargaining unit in anticipation that that will dilute the number of union members that are in the bargaining unit and also make it harder for the vote to pass. Well, the rules are going to prohibit packing in that way to try and circumvent or avoid ballots in favour of recognition. So all of those rules, like I said, April 2026. So for many of you, you'll have very limited a trade union membership or activity on your sites. For many other of you, you might already have recognition, but for those that don't, where you do have an active trade union presence, but there is no recognition in place, it's worth being mindful of the fact that it will be potentially easier for those unions to apply for statutory recognition by early next year, as and when these rules are introduced. Some quicker ones here around statutory sick pay. Nothing much has changed here from the initial announcements, but we can see that there's the removal of the 3-day waiting period, and statutory sick pay will become a day one right. There are some changes as well about what the right to pay will be. For example, it's going to be 80% of your normal weekly earnings or the flat rate of £118 per week, whichever is the lower. That's coming into force in April of next year, and there's going to be a requirement to keep records of the sick pay that we pay. Similar rules around holiday entitlements and record keeping. Again, we're going to be needing to make sure that we are on the spot as far as keeping records of the holiday that's being taken and the payments that are being paid for those individuals, and potential implications, fines for businesses that are not keeping those records accurately. Harassment, again, this is something that's been trailed in terms of the changes. As far as harassment is concerned, there is going to be an obligation, a change in the rules to take all reasonable steps to prevent harassment from October of 2026. Currently, the rules require you to take reasonable steps. That is being changed to all reasonable steps. And there's also going to be an introduced liability to prevent third-party harassment in your workplaces. I spoke to a pub watch group about that a few months ago, who are slightly anxious about what they're going to need to do to prevent their staff when they interact with guests and customers on site. It's important to remember, of course, that this isn't an obligation to stop it from taking place, because you can't necessarily stop it taking place, but it is an obligation for you to take reasonable steps to try and stop it from taking place. And as far as that sort of sexual harassment is concerned, it's going to be treated as a protected disclosure for the purposes of whistleblowing. And there is going to be a call for evidence as well about what organisations can do to prevent sexual harassment. As I said, although we have this obligation, it has been the case since last October, to prevent sexual harassment in the workplace, and a specific claim that can be pursued against an employer if they fail to do that. Precisely what businesses should do to avoid that sort of harassment taking place has been rather moot. So there is going to be a call for evidence that's going to take place to try and flesh out the positive steps that employers should be taking. You can see I put the dates in there as far as when these are all going to be introduced. Flexible working, we're going to see a change there. At the moment, when flexible working requests are made, we have statutory grounds upon which they can be turned down. And although there are rights that someone may pursue in respect of a failure to follow the process in considering that application, or potentially a constructive unfair dismissal claim that someone may pursue if they feel that there's been a breach of the implied term of trust and confidence in a failure to grant the application, or indeed some sort of discrimination claim can be pursued. There's no specific obligation upon an employer to justify their turning down of the request. The rule is going to change, although we're going to still keep the potentially fair reasons rather to turn down a request. What we're going to need to do in the future is only turn down those requests if it is reasonable to do so. There's going to be a switch in the obligation. We're going to have to justify any rejections that we have. We're also going to need to provide written reasons for any refusals. You'll see their consultation on exactly how this is going to work is going to commence in 2026, and we're looking to see those changes come about in 2027. So not imminent, but nonetheless something to be mindful of, especially as more and more businesses are expecting individuals to attend offices or places of work more days a week than has been in the period immediately following the pandemic. Family leave, quite a lot of changes here as far as family leave are concerned. You can see them all on the slide. We're going to see some day one rights as far as bereavement leave and parental leave as well. We're having paternity leave, a day one right there as well, and you can take it after a period of parental leave. We can see that as far as protection from protection of employees who are pregnant or those on maternity leave, we're going to see an extension of that. So essentially putting in place almost a moratorium on redundancies or terminations of employment of individuals who are either pregnant or have been on maternity leave or are returners from maternity leave, except in exceptional circumstances. Again, exactly what that's going to look like. We expect there's going to be some consultation on that in 2026 and looking for that to be introduced in 2027. And you'll see I've got a stop press note at the bottom there. That's because, again, earlier this week, the government introduced, they are now commencing a call for evidence in respect of parental leave full stop. So the shared parental leave provisions, also the amount of parental leave that's provided and paternity leave as well. They're looking to gather information from industry and interested stakeholders at exactly how these rules work at the moment to look to put together something that they think might be more workable in the future. So that is, although we can see these rights on the slide here as to some of the changes that are being introduced now, we can anticipate a further shake-up of that in years to come. The Fair Work Agency is going to be introduced in April 2026. So again, this is an organisation where they're going to police some of the rules around health and safety at work, for example, the payment of national minimum wage, etc. Some of the amendments that have been proposed as far as how this is going to work are quite interesting. So, for example, it's anticipated that the Fair Work Agency may be able to pursue claims on behalf of employees if they don't pursue those claims themselves. They must also be able to provide financial support as well and legal assistance to individuals who are pursuing claims against their employers. So this is quite a big one, actually. Exactly how it's all going to work in practice is uncertain. It's going to be introduced in April 2026. There is a concern, I think, around the introduction of a new agency and the costs that are associated in that and how it's going to work in practice. But the government seems committed to its introduction, and it's quite early introduction from April of next year. There are some other changes in the ERB as well. For time purposes, like I said, I haven't been able to cover everything that's happening, but we are going to see a potential increase, well, we are going to see rather an increase in the time limit to pursue an employment tribunal claim from 3 months to 6 months. That's going to be in October of next year. That's quite a big one. It increases the period of uncertainty for businesses as to whether or not a claim is actually being pursued. The public sector outsourcing protection of workers rules from October 2026, that's something that slipped under the radar a little bit, and we don't have time to talk about that in great detail right now, but where you're taking people out of the public sector, if you're a service provider and there's a 2P transfer where you're taking public sector workers out into the private sector, we already know there's some rules regarding ring-fencing their terms and conditions that would be expected of you from the public sector employer. But these regulations might then oblige an employer to ensure that anyone that they then recruit and employ to work alongside those previously public sector workers who are doing the same job will need to be employed on the same terms and conditions. So again, that's quite a big one. That's definite watch this space one if you're a service provider, and it's worth getting some more information. And we can obviously speak to people about how that's going to impact on them. But it's niche. It's not going to affect everyone, but for those that it will affect, it will be quite a substantial change for them. And we've also seen some rules around gender pay gap reporting as well. So we know that there's an intention or an obligation upon employers to produce gender action plans. We know that many businesses already do this, but this is something that's going to be enforced from 2027, setting out the steps that they're taking to try and reduce gender pay gap within their organisations. And there's some other items on the horizon. You'll see that I've already mentioned some government is conducting reviews of paternity and just general leave obligations. There's a proposal to look into the regulation of umbrella companies as well. There's perception of widespread tax evasion and improper practices that are used by umbrella companies, certainly not all of them, but some. And so the government's proposing to consult on them, how they operate and what steps could be taken to better regularise those. A consultation starting next year, and then we're looking to those to be enforced in 2027. There's the Equality, Race and Disability Bill that is also working its way through. We're expecting that to be published in due course. Not sure when that's going to be, but that's likely to introduce steps, including, for example, ethnicity pay gap reporting and disability pay gap reporting too. And then we are also anticipating shortly the revised guidelines from the EHRC following the fallout from the For Women Scotland case, which I'm sure many of you are aware of, and the definition of a woman and a man for the purposes of the Equality Act and how businesses should be looking to apply that within their workspaces. So there is a lot going on in employment law at the moment, and a lot for us to keep our eyes and ears open. So what should we be doing? Well, we need to be mindful that the bill is going to pass probably in the autumn, I suspect. As you'll have seen from the slides, and you will of course get a copy of these, there are a variety of different timelines that are running here in terms of both the commencement of the consultation exercises and the implementation of any legislation. If you want to be involved in those consultation exercises, clearly any organisation can choose to do so, or you can engage with your trade bodies or other representative organisations to make sure that your views are heard and considered. We're going to need to think about our processes that we use because of these new enforced rights. It's going to put pressure on our managers. It's going to put pressure on our HR teams. It's going to put pressure on our systems as well to track the various rights and obligations and time limits as well that apply to those rights. And we need to think just generally about how we're recruiting and engaging staff, how we're working with them. And there's a lot on our plates. So look, I think I've slightly gone over my 45 minutes that I've been allocated. I've seen that there have been a couple of questions that have come in, but bearing in mind that we are up against our 45 minutes, and I know that people have other things to be getting on with, I will draw the session to a conclusion there. For those that have sent questions in, I can see there's a few that have come in. I will, of course, make sure that we provide a written response to you. We will also provide copies of these slides to everyone that has attended. If there are any additional questions or anything that you want to reach out to us about, then please do so. We're more than happy to engage and to speak to you if you've got any specific questions or queries. But otherwise, all that remains is to thank you all for coming along today. I hope that there's been a few nuggets in there and a few things that you're unaware of, or if all it's done is reaffirm things that you knew anyway, then that's all a good thing too. So I'll just bid you all, I say thank you once again for attending, bid you all goodbye, and I hope you all have a good rest of the day. Thanks.